Hello out there. My name is Laolu Akode and you are on to Inside Sources. But first, here is my take for today entitled, Why Nigeria Will Prevail. It's now 1 year since Inside Sources started. And one thing that we always say on this program is that Nigeria will prevail. When we say that, it means we know that Nigeria will win at the end of the day because every day there is a battle for the soul of this nation. But why do we always say that? Why do I specifically believe that Nigeria will prevail? A few reasons. Number one, there are more Nigerians who aren't satisfied with where things stand today and who insist that Nigeria can and should do better. That quest itself is a basis for transformative progress. If you ask me, but when will that happen? I will respond in the words of Nadine Godima, that author, some Monday for sure. The second reason I believe that Nigeria will prevail is because those who don't wish this country well, those who we can say are perfidious about the wellness of Nigeria, they are not much, they are few. And their greatest vice, their greatest ill is actually greed, which has become for them an affliction. Nigeria will prevail over them because if they don't have a change of heart, that same greed will consume them and Nigeria will win. Number three reason why I believe that Nigeria will prevail is because Nigerians want Nigeria to win. Let me say that again. Nigerians want Nigeria to win. There are more Nigerians who wish Nigeria well than those who don't wish Nigeria well. That is why, for instance, you find out that Nigerians don't really demand too much from their government. They just want the barest minimum to maintain their lives, to live a basic life, and to have a renewed hope. That is why when you see leaders doing some of the things that are even very ordinary, Nigerians are already cheering them up. Why? Because Nigerians want Nigeria to win. Number four reason why I believe that Nigeria will prevail is because there are too many resourceful, resilient, and remarkable Nigerians who are alive on God's green earth. And they are not only alive, they are thriving. There are just too much of those numbers for Nigeria to fail. So we have the tremendous human capacity and we have the potential. Number five reason why I believe that Nigeria will prevail is because God has blessed us with so much abundant natural resources that are just merely for us to tap them, and there is a long list of those, whether they are liquid or solid, and all kinds of natural resources. In this God's green heart space called Nigeria, we have too many of those resources. Just too many of them exist for us to fail. Number six reason why I believe that Nigeria will prevail is because we are just too big. It's because we are just too big to fail and we are too big to be ignored in the Committee of Nations. Whether we are up today or down tomorrow, we are just too big to be ignored. It is difficult to ignore a country the size of Nigeria. Look at it in Africa, or even more so in the West Africa sub-region. If Nigeria were to break up, it will be a tremendous regional catastrophe and a continental fiasco. Nigeria will prevail because Nigeria is too big to fail. And the final reason why I believe Nigeria will win is because our diversity will eventually speak strength and might to us. Our diversity will ultimately drown out the fears and the divisions. And these fears and divisions are often orchestrated by those who want to take advantage and game the system to use it for their own aggrandizement. But ultimately, our diversity will speak strength because diversity by itself is the surplus of ideas, the multiplicity of counsel, the abundance of intelligence, more than enough resources, and a surfeit of imaginations. Nigeria cannot fail. And that's the reason why I believe that Nigeria will win. In conclusion, what we need to do so that Nigeria will win is not to keep silent. Don't be silent on the fate of Nigeria. We have to be relentless in demanding good governance. When we speak up, Nigeria will win. And so let's say it again as we mark 1 year of Inside Sources, that Nigeria will prevail. And there you have it. Inside Sources will be right back. Welcome back to Inside Sources. Today we are having a special segment looking at the issues of the reform in the judiciary, especially with the latest news around the contestation between Chief Afeba Balola SAN and Mr. Dede Farotimi and all of the drama that we have seen. Joining me to have this conversation is a leading voice that has been calling for judicial reforms in our country, a law professor. I'd like to welcome back to Inside Sources, Professor Chidi Odinkalu. My brother.
Compliments of the season, sir.
Exactly, same to you. It's good to have you again right here in the studio.
Thank you for having me.
And thank you for coming.
Thank you.
So, Prof, please help us to, within the larger context of, what has happened, some of the fallouts that we have seen in the judiciary, quite a bit of concern. I remember the particular instance, I think it was 2020, when Justice Amina Ogi, made a very strong ruling against Chief Afeba Balola and one other senior advocate who had brought a case, that Supreme Court had decided, this Payesa David Lawrence matter. And Justice Amina Ogi, now retired, gave a very stinging comment in our ruling to say that that matter that was brought back for the Supreme Court to review itself was not only vexatious, she even said that it is, in her view, a desecration of the Temple of Justice. And she went ahead to impose a 30 million naira, personal fine.
Punitive costs.
Punitive costs against Chief Afe and the other SAN. Now, so that tells us that there are issues around when the Supreme Court can review itself. Can you just educate us around that? Because it seems, in my own reading, I'm not a lawyer, but I think, these things must appeal to common sense.
I'm not sure there are any lawyers in Nigeria left, by the way. That's another matter.
Because it seems to me that that's one of the crosses of the matter in this Dede Farotimi contestation, because he is arguing that the review that happened on the matter of the land case in Osakpa, London, in Lekki, is about the improper review of Supreme Court ruling in the case. So I wanted our audience to have a fair understanding of what is not and what is.
Well, thanks a lot. I like to preface everything I say about law in Nigeria with two health warnings. First is, I'm not quite sure I can claim to be a lawyer anymore. Secondly, the reason for the first is many of the decisions that happen these days, I cannot understand them. The words, each word I read, I can understand. But when I piece them together, the logic just breaks apart in many of the decisions, admittedly not all. Yeah. And so I like to be careful about making any claims about Nigerian law, or indeed putting forward any credentials in law in Nigeria at the moment. There were fairly well-established rules at the time my generation made claims to entering the profession. There were fairly well-established rules as to how the apex court could change its decision. And indeed alter a principle of law that was settled at that level. First of all, in terms of discrete decisions, there's something called the slip rule. So if there's a typographical error or there's a mistake, a manifest error on the face of the judgment, right, a court can alter it without altering the underlying decision. Right. Because after all, judges are human beings, and sometimes mistakes can happen, and some of those mistakes are not that fundamental. However, if it, and to do that, however, you've got to make sure all the parties are present, so that it's open what's happening. And so there was a particular case in Lagos in which one of the most credible judges, probably ever to pass through the High Court of Lagos at the time, Justice A.L. Balogun, encountered something similar in his decision-making, but communicated only with one of the sides and not all the sides in the case. And the Supreme Court took a very dim view of that conduct. If he had not been Justice A.L. Balogun, known for his integrity, his personal integrity as a judge and as a person, I think for most other judges, he would have probably lost his job, for instance. But nobody, I had the privilege of doing my court attachment in law school, actually, with Justice Balogun, and he was an extraordinarily honest, decent man. That was what saved his position in that time. But the Supreme Court can, of course, overrule itself. And when it wants to overrule itself, when the Supreme Court sets out to overrule an existing principle of law, it convenes a full panel of 7.
Okay.
Now, in this particular case, I think what the issue, from what I understand, I may well be wrong in my reading of the facts, there was an original decision relating to 10 hectares of land or something.
Yeah.
And subsequently, on an application for a review, that then evolved to 250 or something.
Yes.
So a fairly significant alteration of the final of the interest, the underlying interest in the case. Now, I have not read the record of proceedings, so I'm not going to hold forth on whether or not there was justification for that. But of course, if you're having a change of that magnitude in the underlying subject matter, people may well have good reasons to question whether that is within the framework of the slip rule, or whether it is within the framework of an apex court, or indeed any court at all for that matter, to alter or review itself with a view to reaching that kind of outcome. I do think there could be legitimate disputes as to that, and I can see how such disputes could ultimately devolve to questions about the credibility of the decision-making. As I said, I've not read the record of proceedings, so I don't want to hold forth on that particular issue, but I could quite easily see that people may begin to think there are smell test issues involved in that.
Interesting. So in your own view, there have been quite a few commentary around how Dele Farotimi was arrested, how they came from Ekiti to Lagos and put him through a magistrate court that refused in its own ruling to deny bail the first time, asking that, look, go and bring a formal application. Days after, brought a formal application, and then they said that, okay, you know what, I'm going to take my time to decide. What do you think is happening in this matter, in your own view? What's your take?
Well, because of the way you framed the question, let me declare my interest. I'm one of those people who have who's done a commentary on this.
Okay.
So I don't want to come here and kind of pretend I'm innocent on this particular matter. But I think people need to know a few things about the underlying principles of law. Number one is that a magistrate's court is known as a court of summary jurisdiction.
Okay? Can you explain that to Nigerians?
Now, a high court, a magistrate's court is a court of summary jurisdiction, and a high court is a superior court of record. That means in the high courts and above, customary court of appeal, Sharia court of appeal, federal high court, national industrial court, courts of coordinate jurisdiction to the high court and above, everything should be on record. And so a high court, if these charges were before the high court will be well within its rights to say, bring an application in writing, because those are superior courts of record. Of course, every court is of record, but not every court is a court of summary jurisdiction.
Okay.
So a magistrate asking for an application.
Sorry, Chidi. So So a court of summary jurisdiction means that when matters come, you deal with it summarily.
Summary.
All right.
Exactly.
Just so I understand. Yeah.
So a magistrate asking you to bring an application in writing for bail on a crime or a charge in which the maximum penalty is 2 years, either has not gone to school properly or has a mission to fulfill. With all due respect. All right? Now, there are 3 categories of crimes known to Nigerian law. Simple offenses. Simple offenses are crimes punishable with not more than 6 months in jail.
Okay.
And so you can dispose of those with fines and, and easily. Now, then you have misdemeanors. Misdemeanors are punishable with not more than 2 years in prison.
Okay.
Those are also not exactly the most serious of crimes. Then, number 3 are felonies. Felonies fall into the category of serious crimes that are punishable with more than 3 years in jail. Right? Now, the maximum penalty, let's leave all the other jurisdictional issues. So let's assume everything is right in this case. The maximum penalty for this particular charge of criminal defamation, the charges brought against Dele Farotimi, 2 years. Yes?
It's not a felony, actually.
It's not a felony under any circumstance. Now, there is therefore really no reason. There's actually no basis. That's no basis for this procedure of, okay, bring a formal application.
For bail.
And then, instead of exercise, and secondly, that the suspect in this situation is entitled to bail as of right, because there is a presumption of innocence. But part of that is also a policy reason. In our prisons in Nigeria, over 75% of the people in metropolitan prisons are awaiting trial. Okay? That means that the prisons are not holding the kinds of people they've been built to, which will be convicts.
Yeah.
And therefore, we're spending assets and lean public resources on the wrong kind of people. And the average duration of pretrial detention is over 3 years.
In Nigeria?
In Nigeria, as we speak.
Wow.
That would be the average duration for a felony. And many of those people will never complete trial. And therefore, there are actually compelling policy reasons why the courts have to make sure that wherever the crime is bailable, they exercise the powers, discretion in relation to bail.
As a means, perhaps, also even decongest.
Precisely.
Reasons.
Okay, so there is a presumption of innocence. The crime is modest at the very best, allowing for every other thing. And there are compelling policy reasons why the magistrate, as I said, any magistrate who will tell you to bring a written application for bail in this kind of case either needs to go back to school or has a mission to fulfill. On that, I'm willing to go on record. It is such a travesty of due process that it has to be said by somebody. But there is something else. You see, Nigeria has 37 or 38 legal systems. Every state is one legal system. The Federal Capital Territory is a separate legal system, and then there is a federal legal system. That's 38. And when you issue a warrant in one state for execution in another state, number one, the crime has to be a crime in the state in respect of which the warrant is issued.
Okay.
That's number one. Number two, when you take it to the state in which it is to be executed, it has to be, a magistrate in that state has to countersign and validate that before execution. We don't know whether there was any validation of the warrant
from Ekiti.
But what is very clear
sorry, you mean that the warrant that came from Ekiti had to be countersigned in Lagos?
In Lagos by a magistrate or a justice of the peace.
Right.
Okay? Now, that we are unclear about, and I'm not going to speculate about that. But when you are talking about issuing a warrant in Ekiti state for the crime of criminal defamation, there is no crime of criminal defamation in Ekiti in 2024.
Well, I read that, and I'm sorry to interrupt.
Please
I read that in your piece.
Yes.
So, Femi Falana, Senior Advocate of Nigeria, says that there are 2 states that are decriminalized.
There are 3. Ekiti is the 3rd.
I see. Okay.
Wale Fakbounda, Senior Advocate of Nigeria, was the Attorney General when that happened. Kayode Fayemi was the governor who signed it into law in 2021. You can verify from them.
Interesting, because, you know, I mean, and I'm happy to hear.
Edo State has decriminalized criminal defamation. Lagos State has criminalized criminal defamation.
So Ekiti is
Ekiti State decriminalized criminal defamation in 2021.
Yeah, because, I mean, everybody seems to respect Fakponda. And when I heard about it, I was thinking that, well, Fakponda was Attorney General for quite a long time.
Wale Fakponda was the Attorney General of Ekiti State, who was responsible for shepherding the
So he actually also did that in Ekiti State?
Precisely.
So how is it then possible for Chief Afe Babalola to write a petition and the police acted and they have now charged, because they've actually charged Mr. Farotimi?
Only the police can explain that. And the CP Legal is a senior advocate of Nigeria, right? Now, so nobody seriously contests that criminal defamation. I'm honestly not sure that they knew that this was the case, that criminal defamation was not a crime in Ekiti State. But the argument now then evolves. Now that it has become clear that criminal defamation is not a crime in Ekiti State, the argument or their position has evolved or mutated. So they're saying, well, they are not charging him under the criminal law of Ekiti State 2021. They are charging him under the Criminal Code Act of Nigeria. Now, that does not exist as a source of crimes for the states.
Can you explain that?
And I will explain that. The Criminal Code Act was enacted as a colonial ordinance in 1916.
Okay.
At that time, we had 3 territories in Nigeria.
Right.
Protectorate of Northern, that's Protectorate of Northern Nigeria, Protectorate of Southern Nigeria, and Colony of Lagos.
Right.
Right? The Criminal Code Act applied to the South, the Southern Protectorate, and the colony. In 1951, we changed from that structure of North-South colony to a federation. And then, following the work of Governor General Bodilon, we split up the South into 2 different regions. So we now had 4 territories: East, West, Lagos Colony, and Northern region. The North, of course, had the Penal Code. And the Criminal Code Act then evolved into the ordinances for the regions.
Okay.
Yes? Now, when the states were created, when Midwest was created by referendum in 1963, it became legacy law for Midwest. And progressively, it became criminal law for the various states.
So what became criminal law?
The Criminal Code Act then got adapted by the various states as a micro-territorialization. The creation of states evolved. It then evolved with them and became the criminal law for the various states of Nigeria.
Created. Okay.
The federal government does not have powers. When you look at the exclusive legislative list, or indeed the concurrent legislative list, the federal government does not have powers for general criminal law for the states.
Interesting.
That means that the Criminal Code Act does not create any crimes for the states. It lapsed as a piece of source of criminal law for the states. The only...
When it did lapse, based on this analysis now?
It lapsed not later than 1967.
Okay.
The only territory in Nigeria in respect of which it is arguable that is applicable is Abuja, because it's a federal territory.
Right.
And I say arguable. I could dispose of that, but it's not necessary for this particular purpose. But as a source of criminal law, it does not exist in Ekiti.
Interesting.
And Chief Afe Babalola himself was involved in a 2021 case in which the Supreme Court decided a similar principle. The case of CIL against Ekiti.
So what's CIL?
It's the name of a company.
No, company, okay.
Yes? But this was a civil case. And in that case, Ekiti State, as in this particular case, had legislated out of existence a piece of legislation called the Public Officers Protection Act, which provided for certain procedural measures in terms of suing public officers. Right? Ekiti State legislated out of existence. And the argument was that since public officers were being sued here, the federal act, the Public Officers Protection Act, should be imported into Ekiti State to provide for what was not provided, what had been repealed by Ekiti State's laws.
Right.
The Supreme Court said no.
You can't do that.
That you cannot do that through the back door. Okay, you cannot back-channel legislation like that. If a state, as a federating entity, has elected to repeal a piece of legislation, you cannot force it through the back door to nevertheless be bound by a law that a state has legislated out of existence. So the principle of law here is very clear. Unless, of course, we are trying to manufacture something unknown to law, in which case we should say so.
It's interesting, this journey that you've taken us through, because, I mean, I'm sitting down here trying to make a sense of the fact, as you have articulated, that criminal defamation is actually no longer in the books. And even Chibafe's petition referenced that, police action. And it's quite, I mean, it's very worrying, for some of us to have to even imagine that in a country where we pride ourselves as free citizens, a country that we are no longer enslaved subjects, we are no longer colonial subjects, that the very idea of retaining that kind of a law, which had a colonial mandate, they brought the law just so they can harass our nationalities and stuff like that. But to now find out that, in fact, Ekiti State in particular has actually ended I mean, it's no longer extant.
That is what the situation is. And, indeed, in 2021 as well, wasn't it? The Supreme Court took time in a decision that it issued in 2021 to provide the history of Justice Ogumumiju. Supreme Court Justice Ogumumiju provided the history in great detail of the evolution of the criminal defamation laws globally, in colonial history.
Right.
And, she starts by saying it is an invention, an innovation in Star Chamber. The Star Chamber was a paid and bought for tribunal in late medieval England that was notorious for arbitrariness, for everything that a justice delivery forum was not supposed to be. And it was meant to be beholden to the sovereign and to be a place where basically, enemies of the sovereign, real and imagined, were humiliated and defenestrated. That's basically what it was. And to think that at this time, and if I could go further and say that in most of the Commonwealth, to be fair to the facts, it's been eliminated. That the criminal defamation no longer exists. And the African Court on Human and People's Rights about 1 decade ago also eliminated it and actually said it does not exist in Konate's case. So the fact that we are here talking about criminal defamation and lawyers are, salivating about it is worrying. Now, let me be quite clear. I'm not at all saying here that there should be no remedies for injuries to reputation at all. No. Not at all, particularly reputations that have been earned through, rightly earned through hard work and investment over time. Not at all. But those remedies exist in civil law.
Absolutely.
The tort of defamation is very clear, and it can be slander, which is where it is oral and publication is oral and not in writing, or it can be libel, where the publication is in writing or more permanent forms of emission. And for those, you've got remedies in civil law. But you see, this is where the problem arises. And for me, I've got to be fairly upfront about this. There's got to be generational responsibility, because our seniors in this vocation have made a mess of the legal process. Why are we having all these byways that are shameful? Because we've created a legal process that they themselves cannot get justice in. If you go to sue for defamation now,
it's a very important point.
You could be in court for another 50 years, right? You take 10 years through the High Court, 11, 12 years, 15 years through the High Court, preliminary objection, you go up to the Supreme Court, you get locked up there on an interlocutory point. By the time you come back, it is Lagos sued on a preliminary objection. Lagos, the most powerful state in Nigeria, in my view, was stuck in court for 18 years. And at the end of 18 years, the case was remitted back to the High Court.
Which case was that?
I think it was a lottery case.
Okay.
Right?
At that. So
Lagos was stuck in I believe the case started 2005 or thereabouts. Sometime around that. right? 18 years.
Wow.
Lagos was stuck in preliminary objections. Now, our seniors in this vocation made a lot of money and a lot of name
From
stringing
this,
out the process of litigation and making the process of litigation inaccessible to all but a few people. Now, in the twilight of their years, in the winter of their years, they find that they cannot get that same process.
cannot deliver justice to them.
Cannot give them justice.
And so they have to
now
browbeat.
they have to manufacture things that are not in the law. This is my theory.
And I think this is what is happening. And it seems to now amount to punishing Dele Farotimi even before a court can hear his argument.
Look, I cannot understand how anyone can look at this in good conscience and call it law. What is happening in Dele's case? By all means, hold him accountable.
Absolutely.
I'm not going to hold brief for anyone on this particular matter, okay? But every rule that can be breached has been breached with impunity. And mind you, the context is what? That Dele, it is claimed, has made allegations about judicial corruption, which are supposedly false. Okay? This is the arcana of the issue. This is the gist of the issue.
True.
And in order to do this, we are showing that there is judicial corruption.
It's incredible. I mean,
how do you do that?
I've had to have all kinds of contestation with my lawyer friends, even some of my, people that you respect. And I don't understand why they are not arguing for a fair process.
And that is the only thing that anyone with a good conscience in this particular matter should argue for. That is, do this by the book,
by the books,
so that we show that what he is saying is not true.
But now you have...
But rather than do that, basically, if Dele had actually conspired with people to show that everything he said is
right,
is said to have said in his book is right, he could not have produced a better script.
It's just...
at all.
Chidi, I must tell you, I find it very depressing.
No, I'm not depressed by this at all. I mean, I was telling a few colleagues not too long before this started that this issue, the argument over judicial corruption and, the state of the Nigerian judiciary is going to come to a crisis point. Maybe this is the crisis that it needs for everyone to see that these things are these things are as bad as people say they are. It is unfortunate, of course, that we have a magistrate caught up in this in Ekiti. Well, I was telling somebody the other day, it nearly happened to me in Kaduna State. All right? In 2019, the 2019 presidential election was shifted by 1 week.
Yeah.
On the 17th of February 2019, the governor of Kaduna State addressed a briefing in which he claimed that 66 people whom he said were Fulanis had been killed in Kajuru. Now, anyone who knows Kaduna State would know that this was a massive, massive bromide. Basically, it was an invitation to mayhem on the eve of a very desperate election.
Oh, wow.
Okay? Kajuru is at a frontier between the south and the north. And the people of the Adara,
okay, who
inhabit Kajuru, are really the second biggest indigenous population in Kaduna State, right? And of course, at the time, there were contestations between them and the governor of Kaduna State. And and their votes could easily have swung things in Kaduna State in either the presidential vote or in the governorship vote, much more likely. And so the governor basically was doing a code red on an entire race. That is exactly was what I heard. When you say 66 people of any particular race have been massacred on the eve of an election, you're asking for war. You're asking for retribution outside the bounds of law.
Right.
The police had told him, please don't do this. We are trying to verify that. The SSS had warned him. But
he still went ahead.
He went ahead and did it. And so I wangled my way. It was here in this studio that I came on this studio and said, he was wrong. What he said did not happen, and it was irresponsible for a governor to do so. And I said we have to call him out. And for that, after the results of the elections were declared, he was returned. He instructed that I be prosecuted for injurious falsehood and for incitement. What I said from this particular
Abuja.
In Abuja. And so proceedings were instituted against me in a magistrate's court in Kaduna State.
Interesting.
Nobody served me with the processes. Nobody told me that was happening. And they, from what I saw, they had called up the case twice. I wasn't, because I didn't know, there was no way I could have spirited myself to that place.
Oh my God.
And then a warrant was to be issued for my procurement from wherever I was in Nigeria. While that was happening, a good Samaritan in uniform saw what was happening and decided to locate me wherever I was. And so he called, I was sitting down one day, I usually don't pick up calls from numbers I don't know, and he called me. For some reason I picked it up and he was like, this is happening here, and this is how far they've gone, this is the plan, and you've got to find a way of addressing this or do something to make yourself safe. So I had to instruct my lawyers in Kaduna State, Gloria Balasan, a House of Justice in Kaduna.
Right.
And we filed a preliminary objection in the court. We moved for judicial review. I can't even begin to describe for you on an open admission what happened in that case. But the good thing is we were able to slow walk the case. And when the magistrate retired last year, he actually did confide things that I find difficult to say. But part of what did happen was he was under pressure to make sure that I was reeled in. And for some reason, he had a conscience and decided he needed some excuse to not deliver on that.
And bail himself out.
And when he got the preliminary objection, that became his excuse for not doing it. But my friend Audu Mekori, who is also a lawyer of considerable seniority, Audu was abducted from Lagos, right? Stephen Keferson, another of my clients from Kaduna State, was abducted from Port Harcourt. And he was detained on the orders of the governor of Kaduna State, former governor of Kaduna State, for over 6 months.
Wow.
So these things,
this kind of stuff.
These things have now been routinized. I'm currently involved in some form in the case of Kizza Besigye, the opposition leader in Uganda, who was abducted from Kenya back to Uganda. But that's extraterritorial for our purposes. The thing is that governments are now doing these things. Of course, the extraordinary thing in this particular case is that this is procured at the instance of a private citizen. Yeah,
and a private citizen who many of us look up to, who is a legal luminary. Let me ask you, Chidi, I mean, you were formerly chairman of the Federal Government Human Rights Commission. Now, so this kind of a matter, you know, which clearly breaches the human rights of Dele Farotimi. What's the role of the Human Rights Commission? Are they going to have an observation brief? Are they, you know, what can Nigerians expect from the Human Rights Commission for this kind of, because this is human rights issue. I just wanted to know what you think about that. You're on that seat.
You know, I left the Human Rights Commission nearly...
Probably more than a decade now.
Nearly 9 years ago.
Okay.
I left on the 12th of December 2015.
Okay.
That was my final day. And I've not been into the commission since then. I've not set foot on the commission since then. I've not attended any event by the commission since then. Because I think it is proper to move on and not look back. Let others do that business of looking back.
Right.
But also you have to afford oxygen to your successors to do things the way they are set up to do them. And I'm not going to presume to instruct the current managers of the Human Rights Commission, whether the chairperson, the governing council, or the executive secretary and his staff, as to how to conduct their brief. You know, if I hadn't been chairperson of the National Human Rights Commission, I would have answered your question quite volubly. But because I have been, I'll beg to recuse myself from that question.
From that question, okay. I mean, it just occurred to me that, you know, if somebody were to make a petition, you know, to the Human Rights, but I do respect.
I mean, the Human Rights Commission has an office in Ekiti.
Yeah.
So I should think that the issues here are sufficiently weighty for the attention of the Human Rights Commission. Okay. What they choose to do is up to them.
It's up to them, absolutely. And that's fair enough. So how do you think that, so you are one of the frontline voices when we're talking about judicial reform. What this case is representing to Nigerians is just reminding us that, okay, look, we do have a compelling assignment to try and reform the judiciary. First of all, how do you think this case is going to end? What's your prognosis?
As a person of faith, I never want to challenge the sovereignty or superiority of the Almighty. Because we are little pawns and nothings in the midst of providential plans. So that's the first thing. All of this, I'm a big man, I'm a big woman, I can do this, I can do that. All it takes is a providential touch on the light switch of your capabilities. And all of that is gone in a moment.
True.
And so for all, that's the first thing, that's where I want to begin here, that people also need to recognize. It's, Nigeria is the one place where everything we begin with God, 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 God. And then when the moment comes actually for us to show that we recognize the sovereignty of God,
we do the exact opposite. We
fall our hand, as Nigerians like to say. Okay? So this is one of those situations where I begin that way. Do I know how this is going to end? I cannot pretend that I don't have a sense of how this could end. But it depends on what end means, you see.
Right.
Because, this case is going to have a sting in its tail. About that, I'm absolutely certain. I've got to say, I did my youth service in Ibadan. And you cannot pass through Ibadan without having some regard or even reverence for Emmanuel Chambers and for what has been accomplished in that place. So, and look, as Africans as well, whoever they may be, if, for people who have lived to 90 and beyond, we also do have natural regard for them. And there is a sense to, whatever their shortcomings may be, after that age, you've got to forgive, you've got to let go, and you've got to allow for the fact that the Almighty has given them, longevity in their innings on earth.
Yeah.
But what you really don't wish on any senior citizen because of that, also is for an obituary that then begins from the end, rather than from
all of the accomplishments of the past.
Accomplishments. You really don't wish that as the story of any senior citizen. And my hope is that in the end, that there will be cooler heads here, and somebody will remind all the protagonists here, that we are all mortal. And very soon, all of this will end. And if it's not for nothing that Christians sing soon and very soon. Okay? Because whether you live for 5 years or you live for 50 years or 95 years or 112 years, it's actually soon and very soon.
True.
And that's really, it's not like I'm a very religious person. I'm absolutely not. But I'm a person of very deep faith. And on these things, I really, really honestly would like to hope that people understand that everything ends soon and very soon. And therefore that we should step back and look at what do we want our obituaries to be. I hope this is not going to be anybody's obituary. So
how can we avert this kind of thing? What has to change in our system? If you have any thoughts on that, what has to change in our system? And you have talked about judicial reform a lot, and I'm trying to not make it too generic. But how can we as a people prevent this kind of situation?
That will probably be the subject of a totally different sit down, because it's a rare, and you know, I've just finished a manuscript on precisely that issue.
Okay.
It's probably due out in another 3 or so, thereabouts months.
Okay.
You know, March, April next year, the book should be out.
Okay.
And addressing in particular the Nigerian situation with the benefit of some comparative information and experience, but also being fairly granular about the manifestations of the problem,
right,
and how we can begin to make some inroads into trying to address it. But for me, at this particular time, the biggest single issue is redefining judicial independence and the values of judicial ethics. We made a mistake. We took a wrong detour at independence in accepting the suggestion that colonial rule endowed us with a legacy of judicial independence. That was the fundamental mistake because of 2 things. Number 1, colonial rule as a fact was incapable of endowing us with an independent judiciary because colonial rule was founded on the opposite of judicial independence.
Yeah.
Every institution was malleable,
meant to,
was subservient to the colonial will.
Right.
So you could not have an independent judiciary. The habits did not exist either, nor did the skills, nor indeed did the institutional neural wirings. So by the time...
And there were no such visions when, you
absolutely
know...
not.
Yeah.
By the time we became independent, there were no independent institutions anywhere. That meant, secondly, therefore, that we should have articulated a political philosophy to underpin, an institutional philosophy to underpin the building of independent institutions. We failed to do that. And I'm not saying this is not anything new. If you look at, say, Tanzania, Julius Nyerere in Tanganyika actually articulated a coherent philosophy of building post-colonial institutions that were independent and had affinity with the people. In South Africa, post-liberation, you had a coherent philosophy built by civil society and the ANC and the negotiating partners in the CODESA and then in Kempton Park. We had nothing of the sort. And as a matter of fact, as we began post-colony, you could see that with Awolowo's, with J.S. Tucker's treason trial, and then Awolowo's treasonable felony trial, and then Adegbenro and Akintola in 1963. That's 61, 62, 63. The unraveling of the whole institutional architecture.
And then 66, we got into the military.
Into the military rule. Okay? So it never happened. We never built those institutions, nor did we create the political consciousness to build those institutions. And so individuals then became potentates and principalities.
Yeah.
Okay? This is the underlying pathology we've got to address.
I agree, Chidi.
Now, addressing it will take time, and sometimes it may even take victims. Okay? And sacrifices. Now, that means that we are now at the place. You know, when you talk about judicial independence, the first thing is, oh, Nigerian Bar Association should do this, NJC should do that, Chief Justice should do that. No. Judicial independence is so important that it cannot be abandoned to judges and lawyers and their incest and politicians. Absolutely not. It is so political. Citizens must take ownership of it. That is why I've stayed on the subject matter. That we've got to politicize judicial independence and independent institutions in order to, we've got first to politicize the subject matter in order to depoliticize it.
And what you mean by that is that the conversation must go outside of the boundaries of the legal profession.
Absolutely. Because if you don't do that, you will never fix that problem.
But what about what you said about the generational change, even within the profession itself?
Yes.
You know, I think there's also a generational imperative, you know, because the ways that these things have been done up until now has shown, like you said earlier, that even the protagonist of the system itself can't even get justice.
And this is why I therefore levy a huge weight of responsibility and expectation, not on that generation, but on my own generation. Because we are a bridging generation. We are the last generation to have seen that Nigeria that offered a bit of promise. My generation and you, we are both the same generation.
Yes, true.
We're the last generation to have seen that Nigeria that offered some promise. And the first generation to have seen that Nigeria that is headed towards regression. We actually do now have the responsibility to force issues on this particular matter.
Interesting.
And you know, I was reading a convocation lecture delivered by Professor Soludo at Veritas University. And his opening line caught my attention. He said that he was there addressing them as the last generation to look after our parents until their death. And as the first generation who will look after our children until we die. Okay? So, you and I are the last generation to have seen that Nigeria of creation's promise. And we are now that generation that potentially is looking at that Nigeria that is at cremation's door. Creation and cremation. That, the question is, what choices are we going to make for the sake of our children? For the sake of their grandchildren? Because the IBBs and the Buharis and the Mecca Anyokos and the Afe Babalolas are beyond the departure hall.
Yeah.
All right? The Bola Tinubus and Atiku Abubakars are not very far from there. We are the people left. And we've got to ask the question, we've got to ask serious questions of ourselves. And when we ask those questions, we should not be afraid of going to jail. Because prisons are not built for rats and rodents, they're built for human beings. And if we have to go to jail, we have lived a little bit of Nigeria that offered promise.
Exactly. Very interesting. You know, I mean, and it's interesting that this is actually evolving. So I think that those leaders, especially those of them that have risen to become presidents, you know, I think one of the last things they can bequeath us is to come out and say, you know what, let's fix these things. Judicial reforms, political reforms, and the economic, all the other things. Let's fix it across party lines, across ethnic lines, across regional lines, across, you know, religious lines, whatever it is that divides us. Because some of them have risen, you know, where you imagine that they ought to have risen above all those divisions to become presidents, head of state. Now they've had it all. Is it not a good idea for them to say, you know what, let's come together and talk about elite consensus and get some kind of development bargain that we will know is the basis of a new beginning for Nigeria? What do you think, Chidi?
I'm not even looking at elite consensus anymore. I'm looking at self-interest. Just brutal, articulate self-interest. You know, the first book I did in Nigeria was at the lead for a team that investigated prison conditions in Nigeria. It was the first comprehensive study of prisons in Nigeria. I mean, I was quite literally jumping into prisons across different parts of Nigeria to collect all manner of information and being seen off, thrown across the fences by prison wardens. 1989, 1990.
Wow.
We came out with a book. It was called Behind the Wall: Prisons and Prison Conditions in Nigeria. It came out 1990. And we launched the book at I don't know whether you know the NLC Hall in Tejosho in Lagos.
Yes.
When we launched that book, we decided to invite, guess who? Chief MKO Abiola. That was the first time I was seeing Chief Abiola. And nobody believed Chief Abiola was going to turn up. Okay?
He did.
On the day Chief Abiola turned up, NLC Hall, which wasn't a natural place for him, he turned up in person. He didn't send a representative.
This was
1990.
Okay.
And he gave us the biggest check we had received from any Nigerian for that project.
Yes.
Chief Abiola did not know that 8 years later he was going to pass on a detainee. And whenever I remember Chief Abiola today, that is the image I see.
That you remember.
That man who, not knowing any of us, showed up for a subject matter in a place that did not seem to be natural to him. And so I will always offer a prayer for Chief Abiola and for the repose of his soul. And I will always offer a prayer for his descendants. Because that, if he had known, maybe he would have done more. But in spite of not knowing, he showed commitment.
He showed up.
He showed up. That is all I ask of the Nigerian elite.
Fantastic.
That the person whom you save may well be
yourself.
May well be your family. And I could move on along this story with General Yaradua. Yes? But I want to just tell the story of Chief Abiola and why I smile talking about him. Because he showed up. For young kids, I was barely 22 at the time. Just under 22. Yeah, he showed up.
Wow.
Okay? And what I am hoping is that someday, as our elite begin to look into this future, they can begin to imagine themselves what happens when they are no longer here or when they are going. And if you look around our country, one thing may strike you. All of that political money. Think about all the kids, whose dads were big politicians when we were growing up.
Yeah.
How many of them have survived with that wealth into another generation?
It's very, very rare.
Thank you.
Very rare. Fantastic. And this is a very compelling point. It reminds me of, I think, was it John Donne, who says that, don't ask for whom the bell tolls.
It tolls for thee.
It tolls for thee. I hope our elites are listening. That bell is tolling for each and every one of us. Thank you so much, Chidi, for a very illuminating discussion again. And thank you for your voice. Please, we need those voices. And like you said, even if we got to make sacrifices for it, it's our country.
The only one I have. I don't have to.
Yeah, and that's why we're doing this. Thank you so much for coming to Inside Sources.
Thanks for what you do as well. And may the Almighty keep us into the next year and beyond.
Amen. 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 Thank you so much.
Thanks a lot.
And that's another edition of Inside Sources. Like we always say, we believe that Nigeria will prevail. That is why we are here. And we will not relent. We will not relent. And hopefully, with God on our side, all of us also doing our part, Nigeria will certainly prevail. Thank you so much for watching. My name is Laolu Akonde. And by the grace of God, I'll see you at the next edition.